representing MRD, the plaintiff appellant. Due to the number of issues and the constraints of time subject to questions from the court, we will rely on our brief on the issues of jurisdiction and the exclusion of some of the testimony of Dr. Peters, and instead concentrate on two issues.
You want to reserve any time for rebuttal?
3 minutes.
3 minutes, that'll be fine.
And I want to concentrate on the issues of duty, and I will address that in 3 phases, and also the ruling on causation. This case stems from the rape of a freshman UT student in Massey Hall in November of 2012, in which we allege that there were failures by the university that creates liability on the university. The first ruling, and I'm not going to show disrespect to the commissioners, but I'm going to emphatically address issues with which we take great exception. And the first one is this. With respect to duty and addressing the overnight guest policy versus the visitation policy of the university, the commission ruled, quote, the overnight policy did not apply because the event occurred in the early morning hours. And then he went on to say, and I want to quote the ruling exactly. This is on page 74 under his finding of fact number 58. Quote, based on MRD's physical condition as documented in the videos taken at 1:42 a.m., she more likely than not would have been aware of any activity she and her male visitor may have been engaged in 15 minutes later at 2 a.m. That is so wrong for reasons that I will definitively show you. First of all, the implication is she knew what she was doing, and at least in part, this was her fault. We take exception to that. But I will tell you who else takes exception to it. You're going to see a continuing theme here. We took 3 depositions of 30026 witnesses of the university. 3. And the commissioner's rulings that I'm going to discuss with you, his reasons for those rulings are refuted by all 3 of the university's own witnesses. And on this issue, one of those witnesses, Jennifer Richter, Title IX coordinator, 32 years at that university, said with respect to this event, MRD did not commit the bad act in this case. But the linchpin of that ruling that the commissioner made was the finding that the sexual event, we say rape, occurred at 2 a.m. That is just flat wrong, 110% wrong. But he finds it, the justification for that, in the SANE report. Next morning when she wakes up with her room a wreck and this unknown male nude in her bed, in extreme pelvic pain, not knowing what's happened, she finally ends up being examined by the sexual assault nurse examiner. And in that 16-page report, the SANE nurse does say that she reported this event at 2 a.m. But in the same breath, the SANE nurse reports not once, but twice, that MRD said, but I have no memory after 11:30 p.m. until 6:15 a.m. I am a blank. She did not even know that she'd been sexually assaulted for sure. There are 9 different questions that she's asked in that examination that she cannot answer because she has no memory of the night, including, by definition, 2 a.m. All she knows is from 11:30 on, I'm a blank. Now, down the road, she did recall waking up, not that day, she did recall waking up at some point in the night with this man pinning her down and penetrating her. She confronts him, he stops, she goes passes back out again, and then she wakes up at 6:15. So to say that this sexual assault has been determined to have occurred at 2 a.m. is flat erroneous. No other way around it. His finding that she appeared to be okay also stands in conflict with the testimony of the university police officer and their security expert. Neither one could say from looking at the video, of course, what her blood alcohol content was when she came back to the dorm, or whether she could even pass a field sobriety test. She had no memory. She knows, and the video shows, this perpetrator did not leave until 7:30 in the morning. They come in at 1:42. He leaves at 7:30. The university's policy prohibits overnight guests of the opposite gender. Mr. Jerry Adams, the housing director, 30026 witness, admits that's the policy. Now, the university has tried to dispute that in this case. But Mr. Adams, 30026 witness, says our policy is no overnight guest of the opposite gender, and that applies on the weekends as well. That is binding. There was a violation of that policy that night, which the university had a duty to enforce, and they admit that they had no policy to enforce the policy prohibiting overnight guests.
Was UT policy that allowed, in this case, a male, different gender, to go upstairs? Just couldn't spend the night.
That's exactly correct. I do not dispute that he could go upstairs. And of course, that kind of segues into one of my next points, which is the login issue and the significance of that. But yes, I don't think there was a prohibition for him to accompany her upstairs. There was a prohibition on him staying, and there being no enforcement to prohibit that. Now, it's also important that the policy says even when you're in legitimate visitation situation, the guest has to be accompanied at all times by the resident. He was not accompanied when he left, and he wasn't stopped, which just again shows the lax enforcement. Now, the next ruling he makes is that a criminal act by a guest against a student is not reasonably foreseeable. That is totally disputed by the university's own witnesses. Jennifer Richter testified that UT had a duty to prevent sexual assault, that there was a concerning level of incidents of sexual assault on campus, and a significant percentage of those, as much as half, occurred in the residence halls. Freshmen like that were the most vulnerable to it. And they knew that these incidents were vastly underreported, but yet they did nothing. Their 3002 witness, Ms. Blaney, testified in spite of their knowledge of the incidents of sexual assault, their concern about it, their duty to prevent it in the residence halls. She of the C Center for several years, being the Security and Environmental Center, knew of no action or coordination between the C Center, Security, UT Housing, and UT Police with reference to preventing sexual assault.
What did the proof show as to, who were the residents of Massey Hall? Generally.
Generally, male and female on segregated floors that did not have access. In this case, MRD as a freshman was required to live in a dorm and assigned to that dorm by UT.
Okay, but it was like her floor was...
segregated to female.
Okay, but males were allowed upon the floor.
Males were allowed on the floor during visitation hours.
What were the visitation hours?
It differed between the week and the weekend.
It wasn't overnight.
But overnight was strictly prohibited.
All right.
Even the defense's security expert admitted that 10% of the sexual assaults on campuses, the perpetrator is unknown. So, the log-in duty. He ruled that there is no duty to log in because there's no national standard of care in universities to do so. That's not the standard. The standard is what did UT know? Based on McClung, based on Smith v. State, like any property owner, the state has a duty to use reasonable care to protect persons on its property from an unreasonable risk of harm. And by the way, This is a for-profit enterprise. Massey Hall, in the year of this event, made a profit of $952,000. They had a duty. Abundant admissions from the university. Sexual assault is foreseeable in these residence halls. Period. End of story. Full stop. They knew it. Now, they had a login system for safety. Their own employees had to sign in and sign out if they came into Massey Hall. Their vendors that they had vetted had to sign in and sign out. Their police officers had to sign in and sign out. The residents themselves, if they wanted to get a volleyball or a video, had to sign in and sign out. But there was no requirement to log in and log out. The one category of people would be suspects for sexual assault, and that are the guests. They had a duty to do that. The only people that didn't have to log in and log out were the guests.
Did the residents have to log in and log out?
They did not.
Okay, so it wasn't just guests, it was the guests and the residents.
No, but correct. But,
all right.
But what I'm portraying here is the residents who are at risk for sexual assault. They don't have to log in and log out. But anyone who is not a resident that comes into that building is required to log in and log out for safety reasons, their words, except for the guests that the university does not know or have reason to trust and knows that there is a problem with sexual assault. By whom? By guests. Even Ms. Richter said, even though there was no policy to log in and log out the guests, it would be easy to do because you've already got the log right there. It would be an excellent idea. And yes, it would have a deterrent effect. Now, if I may just say one quick word on causation. He said that there was no proof that this would have prevented this rape. Yes, there is. Never in a premises case do you have a confession that would make a difference. It's the totality of the circumstances. And in this case, and I'll use this on my rebuttal time, you can take it off. This particular perpetrator had three things that were relevant to this issue. One, he knew that MRD did not know who he was. He knew the dorm did not know who he was because he didn't have to log in and present ID. But the real kicker is, the next morning, after she gets up, and I don't know who you are, what's happened here, he lies to her and says, my name is Tom, and I have put my phone number in your phone before you got up. He lied. He didn't do that. That is proof that it was important to this particular perpetrator that nobody knew who he was, which tells us that had he been required to log in and present ID, that would have been a deterrent that would have prevented this. It was important to him that he was not known.
Your time's expired, Counsel. You have your time for rebuttal. We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
Josh Walker here for the state of Tennessee. I will say, now that I've learned that the university is a for-profit industry, I'm going to go back and ask for a raise. But I primarily want to talk about the jurisdictional issues, but before I get to that, I do want to touch on the lack of reasonable foreseeability, which eliminates both duty and proximate cause in this case, and that's why the commissioner was right in his rulings there. Now, I will say, because of the subject matter jurisdiction issues, I don't think this court has to get there, because I believe the law is that if there's no subject matter jurisdiction, you're supposed to dismiss and not reach the merits. But I do want to touch on this so I don't forget at the end. But before I get to that, a couple of things that the plaintiff raised. Jennifer Richter, you also have to keep in mind her testimony. She said that she was not aware of any issue with unknown assailants, and both Ms. Richter and Mr. Carter and Mr. Yance all testified that the vast majority of these things that happen on college campuses, the accused assailant is known by the victim. This is not a situation where strangers are doing these things. These are people who know each other. Maybe they have a little bit too much to drink, they don't communicate, and then the next day there's an issue about was there consent or not. So that this is not an issue. We don't have an issue at the university with unknown individuals assaulting our students in their dorm rooms. The other thing about...
None?
I'm sorry?
None? You're saying that never happens?
Well, I mean, there is this one, but other than this, there was nobody brought anything up. I'm not aware of anyone, and Ms. Richter wasn't either.
What I'm concerned about is the proof presented to the commission, so there was no proof that this type of situation of an alleged unknown assailant was the situation.
That's correct, Your Honor. And then also, as far as who came into the dorm with the residents, both Mr. Adams testified that the university relies on its adult students to follow the visitation and overnight guest rules and not to bring potentially bad actors into their community. And this idea about escorting guests then ties into the vendors and the employees that the claimant talked about in the opening argument. The employees who are assigned to Massey Hall, and Mr. Adams talked about this, they don't have to sign in and out because they're assigned there. They have an ID that lets them in that building. And so they come and go, and they actually work there, so they don't sign in and out. The residents of the hall who live there all the time don't sign in and out. The hall director, the RAs, those people don't sign in and out. Employees and vendors employees who aren't assigned to that hall and outside vendors, they log in and out because they don't have the manpower to have them escorted when they go through the building. If somebody's there to repair the elevator, they don't have, and they may be there all day, they can't send an employee or somebody with that person to go do whatever they've got to do in all the places they've got to go with that elevator. Because they're not escorted, they don't have to sign in and out. I think that's all I wanted to address the overnight guest policy. And if you look at that, in the commissioner's order on page 83 of his order, I can't tell you the actual page in the record that is, but it's the overnight guest policy. It cross-references the visitation policy. And then that's where the operative language comes into effect. In the visitation policy, it says a student may permit a guest of the same gender to remain in the hall beyond the hours of visitation as an overnight guest. This happened on a Sunday morning, the weekend. Guest visitation was 24 hours. So you could bring guests back, male or female, 24 hours a day from 11 a.m. on Friday morning until 1 a.m. on the next Monday morning. So there is not a period on the weekends where anybody stays beyond the hours of visitation, so they're not an overnight guest. Okay, turning to reasonable foreseeability. Anytime you deal with a case, this is allegations that it was failure to prevent an assault. The two main Tennessee cases that I was able to find and cite to your honors is King versus Anderson County. That's a case where a man had been incarcerated in the Anderson County Jail. His release had been ordered. For some reason, he wasn't released for several hours. And in that period between the order of his release and his actual release, he was beaten pretty badly by a cellmate. The Tennessee Supreme Court reversed the finding against Anderson County that it was not a reasonably foreseeable assault because there was no indication that the assaulter posed any risk to the person who was assaulted. Because he had been in the cell overnight, he was supposed to be released the next day, then there was this delay. But there was no proof during that time that this particular person, and I think the way they phrase it is, was a danger to the individual or class of individuals who was assaulted. And because of that, it was not reasonably foreseeable, and therefore they reversed and entered judgment in favor of the county. The other main case that we relied on is Mason versus the Metro Government of Nashville. This was a secondary school assault. The students had a cosmetology class. They were given kits for the class. Included in those kits was a razor blade or some type of razor. On the bus, I believe going home one day, one student attacked another with the razor blade in this cosmetology kit. And once again, the court found that it was not a reasonably foreseeable assault because there was nothing to indicate that the attacking student had some problem or issue or was a threat to the student who was attacked. The court even went so far in Mason to say it may well have been negligence to give these students razor blades in these cosmetology kits. But because this assault was not reasonably foreseeable, there's no liability for this assault. So that's how important this is. And then within the Mason case, they rely on several other secondary school cases that involve fights and assaults with students, all the same rule. I could not find in Tennessee a case specifically dealing with a sexual assault, so provided several opinions from other states and federal courts where they hold the same thing, that this generalized idea that because sexual assaults occur on college campuses, that does not make any particular assault reasonably foreseeable. And provided that, several of those to the court there in the brief on pages 47 through 48 of the state's primary brief. And because of that, since there's no reasonable foreseeability of this assault, nobody knows who this guy is, nobody knows anything about his state of mind, that can never be proven. Therefore, the claimant could not prove duty or proximate cause, and the commission was correct in making those findings. And as far as factual causation goes, he was also correct because of what I've already talked about. All of the expert testimony and Ms. Richter talked about, the vast majority of these cases, the assailant is known. Ms. Richter talked about that at the University of Tennessee, where these complaints have happened, not infrequently at all. I can't remember if she said it was a majority or not, so I'm not going to claim one or the other. The conduct that occurs that results in an allegation happens in the male's room, who is then his dorm room, who is then accused of sexual assault. Well, the university knows everything there is to know about that person if they live in our dorm room. They know where they are, what their name is, social security number, everything. And the person knows that the university knows that about them. Identification doesn't prevent these things. So this idea that some sort of login or anything like that would have made a difference, the proof is just very contrary to that, and the commissioner was correct in finding the way that he did. The other thing, looking to a national system or what happens at other universities is perfectly acceptable when determining a standard of care. That's what the commission did. The proof was that there was no proof presented that any university in the United States of America used a login system or what was requested by the claimant in 2012 or earlier. So again, that's a correct thing for the commission to look at in making those considerations. Now, subject matter jurisdiction. Took a little longer than I wanted to, but that's what I primarily wanted to talk about. That's the main problem with this case under both the premises liability, which is 9-8-307A1C, and care, custody, and control of persons, which is 9-8-307A1E. The premises liability part first. Two of the opinions that we have cited to the court is the Combs opinion and the Byrd opinion. In both of those, the court references that the premises liability subsection of the Claims Commission Act is limited to a condition of the land or a fixture attached to the land so that it has become a part of the real property. And then there's a very long string side. I apologize for its length, but I did want to express that this is how this has always been applied. 25 other opinions that all apply 307A1C in the same matter, either to real property or a fixture. That's the way this works. Now, I'm sorry.
No.
Oh, I thought you were going to ask questions. A very important question, or a very important opinion here, is the Smith versus Benihana National Corporation case that we cited. The reason this is important is it doesn't involve sovereign immunity at all. So, nobody can argue that it's some type of mumbo jumbo that the state's trying to cook up to protect itself. But in Benihana, a person ate there, had a shellfish allergy, had a very serious reaction and died, filed multiple claims. One of those was a premises liability claim. And I want to get the language correct here, so I don't typically like to read to you, but I'm going to here. But in regarding the premises liability claim, The Court of Appeals said, the allegations in the amended complaint suggest that the alleged harm to decedent was caused by the conduct of appellee's employees in the course of preparing decedent's food. As such, appellants conflate premises liability, which stems from a property owner's superior knowledge of conditions of the premises, with a typical common law negligence claim. The gravamen of the complaint is that decedent was harmed by the negligence of appellee's employees in preparing his meal. Nothing in the complaint indicates that the condition of the restaurant changed between these prior visits and the night of decedent's alleged injury, only the alleged conduct of Benihana's employees. They went on to affirm the dismissal of the premises liability portion of the claim. Now, that's important because typically with a private defendant, you don't have to parse whether it's general negligence or premises liability because you can sue for both. That's much more important to the state because the state cannot be sued for general negligence. It's got to fit in one of these categories or you can't bring the claim. And here, with a private landowner, the same distinction is made. A premises liability claim is something to do with the condition of the premises, not what your employees did or didn't do on that premises. And that's what we've got here, an allegation that they should have checked an ID or had a login system by the person at the front desk of the dorm. That's the same situation in Benihana. It's not a premises liability claim, so therefore there is no subject matter jurisdiction under 307A1C. And also the courts have said that 307A1C extends no further than what you could sue a private property owner for in premises liability. And we've got that limit for private owners drawn in Benihana as well. Then turning to 307A1E, the negligent care, custody, and control of persons. Byrd, well, let me back up a little bit. And we take issue with all the rulings that the two different commissioners made in this case. There's no allegation of anything wrong with the premises. The allegation is what the employee didn't do. And there was certainly never any proof at the summary judgment or trial stage that there was anything wrong with the premises. So we think that at each one of those junctures, it either should have been dismissed under Rule 12, should have granted summary judgment, or should have granted the state's motion for involuntary dismissal during trial for lack of jurisdiction. Under care, custody, and control of persons, again, we refer back to the Byrd opinion. And Byrd took a review of several, I think they say all the opinions, but I know they looked at Stewart v. State, which at that time was the most recent pronouncement from the Tennessee Supreme Court on that subdivision. And they said, looking at Stewart and all the other cases involving this, they all involve an alleged duty by a state official to either physical control over an individual for this part of the statute to activate. That holding was reaffirmed in the Williams opinion 10 or 15 years later when a student was claiming he didn't get his medical degree because of the disciplinary system and the control they had over him. They said, again, that's not physical control, doesn't activate this part of the statute, no jurisdiction. But the important part of that is there's no allegation in this of physical control in the complaint, again, like before, so this should have gone out on Rule 12. The allegation is that we should have had certain policies or procedures. There's a reference to a 1-year residency requirement. But when the claimant testified about that, both in her deposition and at trial, she wasn't required to sleep in the dorm any particular time. She didn't have a curfew. There wasn't a bed check. There was a residency requirement for first-year students. Mr. Adams testified that studies have shown that students integrate into the community better and do better academically if you are required to live in the dorm that first year. That's why that's there. But she wasn't required to actually stay there. Nobody had physical control of her. And they went through several things with her. They didn't tell her what to eat, what to wear, what type of movies or TV she could wear, how late she could stay out, all kinds of things like that. She had control over her life. There was no physical control. And without that, there's no jurisdiction under that subsection. Thank you, Your Honors.
Thank you. Hear from the appellant and rebuttal.
With respect to his argument on jurisdiction, again, we'll rely on our brief. They have continually pounded the fact that the only duty the state has is to defects of property. Smith v. State, like any property owner, the state had a duty to use reasonable care to protect persons on its properties from unreasonable risk of harm that is not restricted to defects in property. And the McClung Supreme Court decision is what was relied upon in Smith v. State. So their argument is just incorrect. His foreseeability argument is interesting. He said that Mr. Adams testified, and he did, as an excuse for why they didn't log in guests while they logged in everyone else, is we trust the students. However, that ignores the testimony of Ms. Richter and Ms. Blamey, both Rule 30026 witnesses, who testified that we know the risk of sexual assault. We know that the freshman women are most vulnerable. We know that they will abuse alcohol. We know that that will affect their judgment. We know that their frontal lobe of their brain is not complete at that point, which makes them vulnerable to bad decisions and bad judgment and make them more vulnerable to sexual assault. Those are UT witnesses' admissions. As to the unknown assailant instances, if you look at Exhibit 16, you will see in the university statistics that there are a significant number, maybe even the majority, of the cases reported that the assailant is unknown. Now, Ms. Richter said the majority of those, we believe that the victim knows who the assailant was, but simply doesn't want to get that person in trouble, so they don't tell us. But she doesn't say it's all of them. She says it's most of them. And their own expert said, in his experience, 10% of sexual assaults on college campuses are from unknown assailants. My time is up. Thank you.
Yeah. Court appreciates both counsel's oral argument this morning and your briefs. I think we understand the issues very well. Thank you. Please call the next case, please.